Welcoming our session moderator, Mr. Divyam Agrawal, partner at J. Sagar Associates. Divyam is a leading practitioner of arbitration law and has represented several multinational corporations, banks, international commercial arbitrations. Mr. Divyam. Our panelist, Al Sayed Abdullah. He has an extensive legal experience gained over 23 years of practicing law in 2 jurisdictions, in the Arab Republic of Egypt and UAE. Our next panelist, Ms. Iram Majid, who is impaneled as an arbitrator with esteemed tag, that's Thailand. In her sprawling career of 17 years, Iram has been in affiliation with almost all prestigious arbitration centers around the globe. And I'd like to welcome our last panelist, Mr. Khan Khalid Adnan. Mr. Khan is the managing partner and head of Chamber of Khan Saifur Rahman and Associates. He is also the managing partner and vice principal of Cambridge Business and Law Academy, a recognized teaching center of the University of London based in Dhaka, Bangladesh. Over to you, Mr. Divyam.
Good morning. Thank you very much for attending this session in these unprecedented times. I think we are hopefully going to have a very engaging panel discussion today, as the topic is very interesting. It is about international arbitration and how arbitration over the periods have become a preferred option over other modes of dispute resolution, including litigation. We have a very, very interesting panel here, and just before I pass on the baton to my colleagues here, I'll just like to give a brief introduction about what this topic is all about. Arbitration, people have this misnomer that arbitration is something which is a very new field. It's not something which has over the years evolved. You'll be surprised to note that in history, there is a study conducted by University of Pennsylvania by a professor called Earl Walliver, and he traced the history of arbitration. And while he was tracing, he realized that even Aristotle at one point of time had referred to arbitration not in the words as an arbitration, but the fact that there can be a dispute mechanism outside a public forum. So it's been there from those times, and it's now over the years have evolved. So more recent in history, like in last 100 years, International Chamber of Commerce was set up like 100 years ago. The idea of setting up of ICC at that point of time was to give a convenient forum to parties to adjudicate their disputes when they are from multiple jurisdictions. Over the years, this convenience has now become preference, and in this unprecedented times, it has now become a necessity. I would say that there was initially a lot of resistance from courts to cede their jurisdiction to what is called as a creature of contract, but thanks to principles like competence, minimum judicial intervention. This procedure has changed over a period of time, and people have now adopted arbitration as a preferred and a regular mode of adjudication of their disputes. There is, in fact, and UNCITRAL has also helped in developing that. Most of the countries now have UNCITRAL model law adopted in their domestic arbitration process, and which is where it's relevant to note that how each country is faring, because we have today in the panel people from 4 jurisdictions. It'll be interesting to see how in their local jurisdiction the arbitration law has evolved, how arbitration has become a more congenial way of dealing with disputes, whether they face any kind of a challenge, whether there are enforcement obligations which they feel are facing impediments, how they are faring in COVID. And that's why I would like to start with the host jurisdiction, which is of Al Sayed. He is from UAE, and I would ask him about UAE specifically, as UAE, I believe, have a change in their law as recent as 2018, when their arbitration law had an overhaul. So I would request Al Saeed to start, and then we'll take it to other panelists as well.
Thank you so much. I will prefer to be standing. Actually, I am a litigation lawyer. And normally when litigation lawyers talk about arbitration, they start to highlight the disadvantages of arbitration. But this is not the case today. I will be very neutral, and I will also try to interpret the disadvantages litigation lawyers are trying to highlight and how we can convert it to advantages. First of all, sometimes they take arbitration costs as disadvantages. But when we know that if you have an agreement in your arbitration and in the arbitration clause itself, that losing party will pay all of the fees, including the external lawyer fees, this clause is applicable. And normally we can see in the arbitration awarded that even the external lawyer fees are awarded to the winning party, and the losing party pay it, regardless how much is it. It can reach to millions even in some of the cases. It's not the same case in the court. In the court, normally you get only the court fees and a very minimal professional fees from the court, like 2,000-3,000 dirham, which never cover the arbitration costs. But in arbitration, we even find sometimes that the losing party pay millions of dirhams. The winning party had to pay to the arbitration panel and the arbitration center. Talking about the appeal and being the award is final, it's the party's choice. Maybe they choose in the arbitration clause that they prefer to appoint 3 arbitrators. They are confident that these 3 arbitrators will decide in a proper way and they will go through the whole file and give appropriate award. And also in the latest amendment of the law and the issuance of the law number 6 for the year 2018 regarding the arbitration law, the court has given the arbitration center the right to receive any interpretation request from the parties within 30 days from receiving the arbitration award to interpret any unclear point. We have faced that recently in one of the cases whereby the arbitration award was not clear about the interest rate and also the cost. And we have filed an interpretation request to the arbitration center, and they have issued their interpretation regarding the fees and the interest in a form of additional award. So it's also an additional or extra chance it was given under the arbitration law, the recent one which was issued on year 2018. Before the year 2018, the arbitration was regulated in the civil procedures law. Few articles, only around 15 articles of law in the civil procedures law of UAE. But starting from 2018, the law number 6 has been issued. It's an arbitration law, a complete regulation for the arbitration process in UAE with 61 articles of law. Regulates every point of arbitration, starting from the appointment of arbitration, the jurisdiction, confirmation that any arbitration will be issued from any certified arbitration center, and even if it's in Dubai, it will be considered as international arbitration. So it has weight. And also I can highlight very quick, the differences between 2018 and right now. Before 2018, when you have an arbitration award, you have to went through process to ratify it in front of the court. You have to open a new case after the arbitration award. You have to open a new case in front of Dubai court, which will go through all of the process, and maybe it will take 1 year or more. But in the new law, number 6 for 2018, we need also to take we need only to take the arbitration award, the original one, its translation, if it's not in Arabic, in addition to the arbitration agreement, and to submit it to the chief of Dubai court for ratification. This ratification process takes 60 days. And normally court, they give the decision unless there is any objection from the other party. After the 60 days and taking the ratification of the arbitration award in Dubai, we have the right to file execution directly. And as I said, unless there is objection from the other party. I also would like to highlight that usually parties, they choose arbitration for many reasons. Language. We have the right before arbitration to choose the language we are going to present or represent ourselves before arbitration. We can, for example, and normally if the parties are foreigners and they feel confident to use the English language, they have the chance to do that before the arbitration. Attendance. The parties also has the right to attend by themselves or their own in-house counsels, if it's a corporate or company, to attend before arbitration. Normally in the court, they prefer to get an external local law firm. And it's not always a matter of confidence in the legal system. No, some people, they are very confident about the local legal system and the Dubai court, but they prefer to have their own language, they prefer to have their own counsels when they represent their case in front of the arbitration. And that is for now, and I will leave the rest of the panels to also highlight what they have. Thank you so much.
Thank you. Thank you so much, Mr. Abdullah. So moving forward, for an effective arbitration, it's also very important to have an accredited arbitrator. While there is a saying that you cannot be a judge in your own cause, but when it comes to arbitration, you can literally decide the judge who will hear your cause. So that's the easiest or the closest way around it. So apart from setting down the parameters for arbitration as to what structuring should be followed in any arbitral process, appointment of an arbitrator also plays a very important part. And we have with us Iram Majid, who is an executive director for Center for Asia Pacific for Arbitration and Mediation. She's an accredited arbitrator having 20 years of experience. So we would like to understand from her, about the parameters which she feels is should be followed while making arbitration as a mechanism for resolution of disputes. B, more on the fact that what kind of a reforms should there be in any domestic arbitration in order to make it more as a more preferred option, and also touch upon the arbitrators, what role they will play, and how we should ensure that there is a transparent and effective selection process.
Thank you so much, Divyam. And thank you so much for kind and warm welcome. So today we are here for discussing so many topics and so many, panel sessions. So, but I would like to tell you that once it comes about arbitration, no panel discussion and no legal areas will be fulfilled and complete without arbitration. You cannot afford not knowing what arbitration is. So I would like to start with a very important case. But before that, I will be telling you that I've been given only 7 minutes. In that 7 minutes, I'm going to discuss about how accreditation is so important for everyone who is established themselves, who wants to establish themselves as an international arbitration arena. Second thing is, what are the parameters which is making arbitration is the most preferred way to resolve your dispute. Then how the pandemic has occurred as an, as a savior for the international arbitration process, and what is the way forward. So I would like to start with a case in the name of Yocus, shareholding versus Russian government. This was the case where the arbitral award claim was, any guess how much dollar? The award? Any guess? More than 100 billion US dollar. And how much the council is going to get in this matter? The claimants council got 50 million US dollar. So if you want to make that kind of money out of international arbitration, so the first and foremost thing is you have to get accreditations. You have to get accreditations. Suppose if a person who is practicing as an arbitrator or arbitration lawyer or the practitioner or in-house counsels, but if simple they are practicing in this area is not sufficient. Unless you are having a domain expertise, subject expert and the process expert. And that is what the parties are looking for. And the parties are looking for eminent expert, domain expert and the subject expert and the process expert. How they will be getting that? That is only possible through seeing your profile, seeing your CV and everything, and that what accreditations you are having. If suppose you are having accreditation from SIAB, from APCAM, from other institutions, that will give you preference over others. So that is how the users will be selecting you. And that is the most important way to establish yourself and establish your career in international arbitration through getting these accreditations. You cannot afford not having these accreditations because these accreditation establish the credibility and professionalism. If suppose somebody wants to have an arbitrator and even the lawyer as well. So there was a survey in 2013 which says that the people are looking for only those who are having accreditations. And that is why the APCAM, Asia Pacific Center for Arbitration and Mediation, providing accreditations. And that accreditations is not only working in 1 country, 2 country, 3 country, 4, but it includes 10 countries down the line as of now, including Australia, Malaysia, Hong Kong, Nepal, Korea, Australia, India, yes, India as well. So we are having this many countries where you can practice, where you can be having an accreditations. And it is not, we are not stopping here. We are also providing impanelment. So now if you look about any institutions, either they are giving accreditations, throughout India I'm talking, either they are giving accreditation or either they are impaneling you. No countries are giving both. And not a single institution are giving both. So for the very first time in the entire world, APCAM is giving you accreditation as well as impanelment. And that is with a single set of impanelment as a neutral, single set of rule and uniformity. So that is how important for you to establish yourself, to get an accreditations and all these things. Secondly, the parameters. If we come about the parameters. So what all the parameters the users are looking for? Because whenever we are talking about arbitration, it is party-centered, party autonomy. So we need to understand what parties are wanting, what they want, what they're looking for. So they will be looking for the speed, confidentiality, privacy concern, rules, choice of law, and selection of seats. So these things can be possible only if they are going for arbitrations. And that is also for the institutions, because I am from the institution. So I will be telling you that how institutions are having or carrying a lot of weight on the shoulder to, to establish this practice of arbitration and to making a country as an arbitration hub. So if you go for an institution, the institution will provide you administrative support, best case management, emergency arbitration, structure of third-party funding, and preliminary reliefs. See, and moreover, above all, AMA protocol. So if we talk about the emergency arbitration, so suppose if a party is in emergent need of any relief and the tribunal is not constituted so far, so for that, they should not wait. They can go and they can invoke the emergency arbitration rules. And that can be possible only if you are having good and the best and effective rules. And that is something which make any institution the best, to go for. So emergency arbitration is there. And if I talk about the AMA protocol, so AMA protocol is ARB Med ARB. Here, if the parties can't wait to complete and conclude the arbitration, and they want an emergent result and the emergent fruit, so what they can do, they can invoke arbitration, and there they can create a mediation window, and thereafter, once the settlement happens, they can go back to the arbitrator to pass and consent award. And that award can be enforceable under United Nations Convention anywhere. I think 168 countries. So that is how this is a speedy and party-centered and more effective way to resolve your dispute. So we have ARB-MED-ARB, MED-ARB-MED, and many other kinds of hybrid mechanisms through which we can approach access to justice. So now, if we look about the pandemic, how the pandemic has affected the entire, arbitration, mediation, negotiation. So I know that everyone now has shifted from physical to virtual. The same was with the arbitration as well. And 12 countries, 12 organizations in last year, April 2020, came forward and gave a joint statement saying that we are shifting from physical to virtual. And it is so swiftly they started, giving the provision for online mediation, online arbitration, and online hybrid mechanism. That was not an easy task, but with the help of institutions, it is possible, very much possible. And with this, many institutions came up with the online guidelines and many rules and online rules, ancestral technical notes, and we are using, this Seoul protocol, because that is also based on the ancestral technical notes. So that is how the pandemic has also given a space for online. And now I feel that online will here to stay. It will not go. But it is a parallel mechanism like an ODR. It's something which is here to stay. And we should be very careful and mindful, and we should not delay in understanding the technologies. Otherwise, we will be very late in using these processes. And now, if I say even AI, I have witnessed AI, artificial intelligence powered arbitrations. I have seen in New Zealand they are using the blockchain, ledgers for understanding the award and all. But in many countries it could not be possible, because blockchain mechanism is the award will be in a blockchain, and it is not possible for under the New York Convention to recognize that. So that is all the enforcement for the enforcement purposes. That is why blockchain may be a way forward that we are looking for. Thereafter, if I talk about the country, how a country can become arbitration friendly. So for that, there are two important things which we need to understand: that the process before arbitration and the process after arbitration. So once we talk about the process before arbitration, that is an appointment of arbitrator, the most tedious and hectic things to complete. And many parties are, they keep on running here and there. And second is, after arbitration, challenges and enforcement. If we are able to cope and give an effective management for the appointment of arbitration, arbitrators, sorry, and for the enforcement and challenge mechanism, then I am 100% sure that arbitration and mediation is the future. This is future. And if the tribunals, the arbitrators, and the court has to work as a single unit for that. Say, I'll give you an example. Let's suppose a country A and a country B. Country A is going for an arbitration, and country B is also going for an arbitration with the same parties and the same dispute, suppose. Country A is also under some same institution, and country B also under same institution. Country A has completed the arbitration in 6 months. Country B has also completed arbitration in 6 months. Now, challenge. So country A, one party challenge, and decided in 3 months. The award finals in 3 months. Now country B, 3 years. Which is the most preferred seat, A or B, when it comes for the enforcement? Yes, it's A. So that is how the responsibility is for the country, for the court, and the institution. They have to work as a single unit. We cannot say that the entire burden is on the institution, entire burden is on the practitioners, but court has to look into the enforcement, challenge, and appointment mechanism. Then only the practice can be very, very effective. And I must repeat it, it is future. And now, the way forward. So for that, I feel there should be more women. I say there should be more women. Why? Because in arbitration, I have not seen many women are working. Now they are stepping in, but women are considered to be the expert in process because they are born expert. I'm sorry if, yeah. So I must say that we need more women who can lead in this area, and that is the way forward. Women in arbitration. So I get a goosebumps when I say about it, because that is something which my initiative is, and I want to take lead into it. And anyone from here, if they want to do something into it, please, I'm here, and we can make something on this. And with this, I think I have exceeded more than 7 minutes. I'm sorry, Devyam is looking at me, and I'm handing over it to Devyam. And if you have any question regarding accreditations and how you can establish yourself in all those countries, what are the requirements from you, what we need, that we can discuss. If there is a long question, that can be sent to me on the mail. So thank you so much for listening me patiently. Thank you.
Thank you, Iram. So from Al Saeed and Iram, they've actually covered a very interesting gamut of topics here. As Al Saeed pointed more on the proceedings during the arbitration, what are the benefits of having arbitral process, like cost of arbitration, language, parties' convenience from taking it from multiple jurisdictions. Iram highlighted the aspects of how in the beginning of the arbitration you have to have a selective arbitral process where you have accredited arbitrators and you have emergency arbitration. And then with respect to post the arbitration, whether there will be a finality of award, what are the challenges, what are the enforcement procedures. So while we understand the UAE concept of it and how the institution will approach it, would like to understand from Khalid Adnan here, who's from Bangladesh, as to how his country has evolved over a period of time, what kind of reforms have been introduced in your jurisdiction, whether there is finality of award, how long the challenge takes, how COVID has impacted the entire process. Over to you.
Thank you, Diva. Actually, I have learned a lot from the speakers, and I would go a bit off topic, so far as the topic is concerned. Many years ago, I read a book called Bleak House, written by Charles Dickens. I can't exactly recall the exact facts of that book, but what happened was like that. That was about a lawsuit being dragged over for years after years. And in the end, one of the parties won the case. Mr. Dickens commented in the end part of that book that it is not any of the parties that won the case. Rather, the only parties that won the case were the lawyers of the case. Because even if one party had lost the case, the lawyers of that party got paid for the services. And then, so far as the topic is concerned, I would like to go to the report forwarded by Lord Woolf under the UK jurisdiction in the year of 1998. Lord Woolf said that the time has come for us in the year of 1998 in the UK, the time has come for us to look forward to go for ADR, that is alternative dispute resolution, in order to avoid the cost, delay, and complexities, which are the essential features of the adversarial process under our civil litigation system. And from my study in the UK, what I learned was that ADR is a thing which is very much respecting the mindset of the parties. You know, the parties would have that mindset. And what's that mindset? The mindset is like, you can settle a complicated dispute over a cup of coffee or over a cup of tea. You preserve the relationship, the relationship is there, and you also get to resolve the dispute. So if the parties don't have the mindset to resolve dispute over a cup of tea or coffee, then obviously that will be a problem for both the parties. So if the parties think like, okay, we would go to the court and we would see how it works, the country where I come from, that is Bangladesh, we have got adversarial procedure in our litigation system, which means that the parties are in control of the dispute. So when the parties are in control of the dispute, rather than the courts or tribunals, it means that the party who would lose, or the party who would think like it might lose, it would try to delay the procedure, and there are so many ways through which the parties can do such things under the adversarial procedure. My father was a senior advocate of the Bangladesh Supreme Court, Mr. Khan Rahman. When I started to practice law, my father said, like, son, if you want to be a good lawyer, what you should be trying is like, you should be trying to avoid litigation. You should be trying to instruct your client that go for settlement and like don't go for litigation. And I was amazed to see like Sir Rao over here. He said the same thing today, you know, and Sir Rao is also a senior advocate of the Supreme Court of India. So it seems like great minds think alike. And I tried to apply this mindset from the very beginning of my practice. And I tried to encourage my clients to go for ADR rather than going for the court proceedings. And in the process, I have lost hundreds of clients and hundreds of payments because in our country, clients prefer to go for courts. Clients prefer to go for, they think like court judgments would be more better than the judgment of the arbitration, which is in fact otherwise, because the tribunal award is basically final throughout the world and is binding and is legally enforceable. But again, the problem is with the mindset. If the parties don't have the mindset, I believe that the law of ADR would not get developed in Bangladesh in the next 5 to 10 years. But obviously, I'm thinking like as the global culture is getting developed, and as Mr. Rao sir has also mentioned about the incorporation of ancestral laws, we have also incorporated the ancestral laws by way of the domestic law called Arbitration Act of 2001. And I believe that obviously these things will help us a lot. And as I have told, like I am learning a lot. Miss Alize, she told that it's all about culture. Yes, I definitely believe that it's all about culture, because when you're thinking about ADR in the UK or in the USA or in Singapore, the culture is different, you know. And when you are thinking of ADR in Bangladesh, the culture is different. The culture that I have just told you about, the culture is like parties would very much like to go to the courts, and lawyers would also very much like to go to the courts. And one of the main reasons I would say that is like sometimes arbitration is very expensive. It's very expensive. And the parties would not like to bear that expenditure. But if they think about the long run, they would gain more in arbitration than in the court proceedings, because in court proceedings, obviously the payment is low when it comes to day-to-day hearing, because there is no package type thing or something like that. So lawyers would prefer to earn money on a daily basis, and parties would love to pay on a daily basis. But if they like calculate after 10 years, after 15 years of litigation, how much money have I spent on that case, they would see that they have spent more money than they would have spent had they gone for arbitration or ADR. So again, this is a matter of mindset, I would say. Like obviously in the beginning, it would cost you more, but obviously if you think about the long journey, it would give you more fruits, I believe. So for me, for a developing country like Bangladesh, it's mostly about the mindset. Culture is important in that respect, I would say. And one factor which is very important, that is like when we are talking about international commercial arbitration, one very important factor is the cultural diversity, because parties from different countries are coming, and parties from different countries have different religion, they have different values, they have got different taste of humor and different types of communications. So if a country wants to be a good destination for international commercial arbitration, I would say that the arbitrators would have to value those cultural diversity. Because from my experience, what I found like a joke in the UK, that's not a joke in my country. So like jokes do differ from country to country. Even if you are using the same language, in some countries, in some cultures, the language would be termed as offensive. So I believe that not only neutral arbitrators are required in order to facilitate the international commercial arbitration process, I believe that we need arbitrators having extensive experience in the relevant matter. Like if that's a construction dispute, obviously he or she should be an expert in the area of construction disputes, and like that arbitrator should be respecting the cultural diversity, and he or she must have some knowledge about the culture of the parties who are in the arbitration proceedings. I would not take more time about the enforcement procedure. I would like to point out a few things. The problem with the enforcement procedure under our Arbitration Act is, so far as the foreign arbitral award is concerned, when you have won an arbitration award, you'd have to come to our jurisdiction in order to enforce that award. And the problem is, under a law, the award is being termed as a decree. And in order to enforce that award, you would have to apply, the party who owned the award would have to apply to the district court of Dhaka, Bangladesh, to enforce the award. And in the district court, again, the Code of Civil Procedure applies, which is a law which was enacted in the year of 1908. That was a law from the British period. And again, that's a problem, because like you have won an award, but when you are trying to enforce that award within your local jurisdiction, within the jurisdiction of our country, you are again in the civil justice process, which is adversarial in nature. So the things would get delayed and delayed. So that's a problem, I would say. So in order to solve that problem, I would recommend that fast-track arbitration system can be introduced, setting out a very strict time limit as to when and how you would have to complete the whole procedure. And I would also recommend that the Parliament should be thinking about imposing sanction or cost in case the party tries to delay the procedure by using the adversarial procedure. I think that might help a lot in the process of enforcement. Because otherwise what would happen, and what is happening in the country is like, ADR has become not alternative dispute resolution, but additional dispute resolution, because you have won an award, then again you would have to come to the civil justice procedure. So that adds up, and your thing would just get delayed and delayed. And in terms of like intervention of the court, this is a very important thing. Under our law, there are so many spaces through which the domestic courts can interfere in the award. And the domestic court can even give interim measures, or the domestic courts can even interfere in the arbitration proceedings. I think that this practice should be highly discouraged because of so many factors. Because we would have to understand, Parliament would have to understand that arbitration proceedings is completely different and court proceedings is completely different by way of its meaning, that is ADR, that is alternative dispute resolution. So the court should not be interfering with the process of arbitration proceedings. When the arbitration tribunal has given an award, I strongly believe that the court should honor that belief. Because why a party would go to arbitration? A party would go to arbitration, as I have told you, it's a matter of mindset, with a belief that the award that I'm going to get is final, is binding, and is legally enforceable. So if my award is being vulnerable to several challenges on vague grounds, and if enforcement takes time, then obviously these things are hitting the basic fundamental principles of ADR. So I think that Parliament should be thinking about these areas. And during this time of pandemic, there is an issue of virtual adaptability, as Iram has told. And like, I would not go over there in details, but our Arbitration Act has given the parties and the tribunal ample power to follow the procedure, to decide on the procedure, to decide on the place. So it doesn't specifically refer to anything respecting virtual hearings, but we can term Zoom or Microsoft Office as being different places, right? So the parties have got ample freedom to choose place, to choose on procedure. So obviously they can choose to go for Zoom, they can choose to go for Microsoft Office. And in this way, I think that in Bangladesh, we can come forward with the virtual hearing procedures, because so far as our regular courts are concerned, we are doing virtual hearings. So this thing can be adopted. And we have got BIAC, that is Bangladesh International Arbitration Center. BIAC has started to adopt these virtual hearing proceedings. So I think that I am out of time, and thanks for your patience. Thanks everyone.
See, I would like to supplement what Mr. Khan has said. See, when a person is not aware about the difference between the adversarial and collaborative practice, so they will be behaving like the kids who are playing with the mud, and they will not going to have a bath in the tub. So if we need to make sure that the kids should go and have a bath, so we need to put them from where they are playing, and we have to take them to the tub. But we need to ensure that the water of the tub and the temperature should be very, very convenient and comfortable to the kids. Then only they will stay over there. Otherwise, they will again come back to play in the mud. So for that, the responsibility is on each and every person in the practitioner, arbitrators, institution, the court, that we need to make the water temperature comfortable. Thank you.
Thank you. Thank you, Khan Khalid and Iram. So what I take it from Khalid was that there has to be a confidence in the judicial system. If there is a systemic inertia and there is this lack of inherent confidence, then that also results in choosing arbitration over the court mechanism. Like in India, we have, in court system, we have around 40 million cases which are pending right now. Just imagine the number there, and that itself takes away the starting point of any dispute when you don't see the light at the end of the tunnel. Another aspect which we were just discussing was the litigation cost. Like again, another statistics I'll share with you, that around $5.9 billion are expended in India on litigation cost. That's just the litigation cost, not the claim amount or not the ultimate what the client is likely to get. It's just the litigation cost. In arbitration, you have this unique feature where a successful party is likely to recover that cost. In litigation, although there are courts have inherent powers to grant that kind of a cost, but because of the historic systems we are moving with, they just don't give you that cost back. So arbitration, another important aspect is that you recover that cost. Even if you have expended a higher cost, you will ultimately get that. Apart from that fact, the process of, like in India, the process of appointment of the arbitrators have evolved over a period of time. Now there is a minimalistic judicial intervention. There used to be scenarios where parties have appointed an arbitrator, they have nominated their arbitrators, and the presiding arbitrator is not nominated. Parties end up in court seeking court's assistance in that, and that assistance results in the court adjudicating literally the entire dispute. Over a period of time, that process has thankfully changed. Now the courts do not entertain any kind of a discussion or adjudication on the arbitrability of the dispute. Now it is just simpliciter whether there is an arbitration agreement in existence or not, and you're sent back. We have an amendment which have been introduced where now the courts will not even interfere in this process, and there will be arbitral institutions that are going to be designated to see into this process whether the proper institution is appointed, proper arbitrator is appointed, and the proceedings are taken from there. When it comes to the challenge, yes, there is again, for a country like India, yes, there is a difficulty there. The challenge procedure is prescribed, but thankfully the courts have diluted over a period of time what are the challenge options or the challenge grounds you have. Now it's limited to public policy and morality, and whether the award is going to shake your conscience. Those kind of things are there, and though hard to explain, but they are there just to give you that it's not a matter of routine that you can challenge and get away with removing the award altogether. Now the challenge is more towards that if there is actually an inherent flaw which actually goes to the root of the entire arbitration, then only any challenge is entertained. For enforcement, for foreign awards, like another aspect I think which is important for the discussion is that while domestic arbitration, domestic courts are fine, but what happens if I have got a foreign award, and whether if I want to come to India and enforce it, then again, Indian courts are now very receptive towards rejecting any request for challenge at that stage. In fact, courts have said that recently, as recent as last year, Supreme Court has said that an enforcement court in India cannot actually look into any kind of challenge. Their procedure is limited to the execution and enforcement of the award. Plus, time and again, our courts have said that at the stage of enforcement, you cannot reappreciate the evidence. You cannot have a round two there. So yes, the law is evolving. There have been impediments which we all have faced. Even COVID is, as Khan rightly pointed out, COVID is another unknown devil we all faced. But from there also we had this learning that arbitration has come out to be a better mechanism. I from sharing an experience, I conducted an international arbitration which was seated in London. It was the interim application was supposed to be argued in the month of May 2020. The entire country, and rather the entire world, was in lockdown. So we managed the arbitration hearing where I was as the briefing counsel sitting in India. My QC was sitting out of London. The arbitral tribunal, two of the arbitrators was from London, one from New York. My client was based out of UAE. The opposite site was based out of Singapore. We all converged on a one virtual platform. In that virtual platform, we did not had to expand money towards travel. There was no requirement of spoiling the environment by having more air miles attached to all of us our name. We managed the entire hearing seamlessly over a virtual platform. There were virtual breakout rooms available in the platform. Parties could have, even the tribunal could have taken a break, went to another virtual room, discussed some questions and come back to the parties with any queries. Parties were also allowed, there were a proper protocol that was laid down. In fact, many countries evolved protocol. There was a Seoul protocol, Vienna protocol that was put in place to guide people that how you have to conduct these virtual remote hearings. And in my view, it really went seamlessly. Apart from a few niggles here and there, parties managed to conduct arbitration in a seamless manner. We had live transcription also happening at the same point of time in a virtual manner. So all in all, I would end this discussion with a thought that, as Darwin has said in Origin of Species, that it's not the most intellectual species that's going to survive. It's not the strongest that's going to survive. It's a species. The species that's going to survive is the one who's going to best adapt to change and learn to evolve over a period of time. So thank you very much for this discussion, and we have now opened the floor for any questions from any one of you, please.
Mr. Agarwal, here.
Yeah, sorry.
We have a couple of questions from our virtual attendees as well.
Right.
So I'll start with those first.
Yes, please.
So the first question is, what you would advise lawyers who have done lots of training in arbitration and mediation, but they need to get their first case? This is the first question.
See, first of all, if you have completed your training programs and all, you have to advertise it. And you have to make it, and the public and the social media that, yes, you have completed all these things. And you are having an expertise into ADR or the arbitration mechanism. So after that, because that is only make yourself, more and more into the society so that you can grab more and more work into arbitration. So getting a work is something which is a referral and which you can get through your connections. But those connections should know about that, yes, you are expert in process, you are expert in this industry, and you are expert in the subject. Thank you.
Yeah. Second question, if you have there. Otherwise, we'll move to the audience.
Thank you, Ms. Majid. Second question is by Yogesh V. Nair. The question is, and the event as there are different laws, is it not a need and necessity of time that there need to be a universal law for implementation of orders, be it arbitration?
Yes, I think that's something. A unified procedure is definitely required. The closest example we have is UNCITRAL model law, which have been adopted by most of the countries. They are following that procedure with a little bit of tinkering in their process. But yes, if arbitration has to act in a global manner in order to ensure that a similar kind of a relief is granted in all jurisdiction, there should be a uniform code dealing with this process. But unfortunately, that's not the position right now.
Third question is by Zahir Abbas. It is said that justice hurried is justice buried, and on the other hand, it is said that delay defeats equity. Then what would you say about these two?
Actually, the thing is, so far as the ADR is concerned, the main aspect of ADR, in my opinion, is to have extensive expertise on the area, number one, and number two, it would have to be really fast. So the purpose of ADR is to avoid the delay that is being caused by the adversarial process of civil process. So I believe that so far as ADR is concerned, this is not a concern, because if you have a very good institution conducting the arbitration proceedings, I believe that your justice would be served in due time. But the problem comes afterwards. The problem comes in terms of the enforcement within your jurisdiction. That depends on from which jurisdiction have you come.
I would like to supplement to this as well. See, we should not look into the hurried, buried, and delayed, denied, but we should look into the fundamental justice and institutional justice. So we should look forward that we should get fundamental justice, and that could be possible through ADR and arbitration. Thank you.
Mr. Adnan, thank you, Ms. Majid. Now we'll be able to just take one more question from the audience. Mr. Dalia, please.
A very good afternoon, the panelists. I'll come a little in the center because I can't really see the panel clearly. Thank you.
Thank you.
So my question to the floor is, there are developed arbitration centers like Hong Kong, Singapore, UK. On the other hand, we have developing arbitration centers like India, Bangladesh, who are trying to be hubs. In the current times, when arbitration has also become global and it has become virtual, as rightly pointed out, I can sit at my place, conduct an arbitration seated somewhere else, having an arbitrator from another country altogether. How do these countries who are developing, and not talking about the individuals, but how do the countries develop themselves further to bring to a more global standard? Because now we are not just like an Indian arbitration is not limited to India. A Bangladeshi arbitration is not limited to Bangladesh. But we are now fighting on a global stage, thanks to the virtual world. So how do these countries bring forward parity and equity?
I think it's important to have a robust mechanism in place. Plus, as we discussed, that we need to ensure that accredited impaneled arbitrators are there on the board. That really makes a lot of difference. At the end of the day, one of the reasons why people are choosing arbitration is because they would want to go into an expert to determine the dispute. There are technical issues involved, and people would want that technical issues to be resolved by somebody who has expertise in that particular arena of their dispute. So it's important, to have a mechanism where they ensure that they have virtual platforms available, they have seamless exchange of documentation, they have a complete procedure prescribed. Why is ICC, CIAC, LCIA, those names are more prominent? Because they have a robust mechanism already in place. So once you have that mechanism, once you have the arbitrators on board, and once you start promoting it as a preferred mechanism in your country, sooner or later it will arrive at the global stage. Any panelists would like to add anything? Yeah.
Thank you very much.
That's why we are coming with the institutions like AppCamp, where you can have a similar set of rules in more than 10 countries.
Yeah, we'll take one. I hope we have answered your question.
Absolutely. Thank you very much.
Thank you. We'll just take one more question from the lady there.
Thank you. Yes, I have a question regarding the small companies that are dealing with governmental entities. So we all know that governmental entities are very powerful, here in Dubai at least. And sometimes we are afraid of having a conflict or a dispute with the governmental entities because we are afraid to have biased or unfair settlement of the dispute. So my question is, do you think that arbitration is a good approach and a good way to solve an issue with a big governmental entity?
He will answer.
Hello. I would like to answer your question, and first of all, two parties should choose the jurisdiction. So when you enter into a contract with government authority, you both have the right to either choose courts or arbitration. But on the other side also, and talking about the influence and the confidency, I would like to highlight that when you enter into any dispute with a government authority, you will not file it directly in the court. In Dubai, for example, you have a pre-stage before filing the case in Dubai court against any government authority, which is filing the request or the claim first before the ruler's court of Dubai, and they have the right to call both parties in order to mediate and try to find out an amicable solution between both parties. If they fail to find these amicable solutions between these two parts, including the government authority, the ruler's court give in all of the cases, I have seen all of the cases, recommendation or a referral letter to the dispute to Dubai court. And also I have seen in many cases judgments issued against the government authorities or departments. So I believe, I hope this would cover your point.
Thank you very much.
Thank you. Thank you very much. Over to you, Babu.
Thank you, Mr. Agarwal, Ms. Majid, Mr. Adnan, and Mr. Abdullah for an eye-opening session.